You got to admit you're Peyton Milton, because he's got a responsibility to give that either to the defendant or the defendant's attorney. And if you want that discovery right now, then you do have to agree that you're Peyton Milton.
I am the agent authorized to represent him.
No, that's not. That's again. You know. Okay, look. Again.
I have.
Okay, stop.
Sure.
Stop. What's your name, sir?
I am the agent authorized to represent Peyton Ansley John Milton.
So, are you Peyton Ansley John Milton? You don't know.
It's my understanding that I'm not allowed to answer that question directly, Your Honor.
Okay, well that's a misunderstanding. So it looks like Ms. Langley's your attorney, at least in one of these cases.
Negative. I'm pro se. Actually.
Okay. Well then, if you're pro se, means you're representing yourself,
right,
which must make you Peyton Ansley Milton, because
Negative.
Someone pro se is representing themselves.
I'm not allowed to confirm or deny that, from what I understand, Your Honor.
Why are you here?
To represent myself.
Okay.
I understand.
Hang on just a second.
Sure.
Ms. Langley, I'll be with you in a second here.
Thank you, Your Honor.
I want to take a seat. Before we get started, I'm going to talk for a minute. All right.
Absolutely.
So Peyton Milton, we kind of went round and round with each other about whether you are or whether you aren't Peyton Milton. I can only conclude that you are Peyton Milton, simply because at some point you said you're here to represent yourself. Peyton Milton is the person charged. So if you're here representing yourself, you must be representing Peyton Milton. You must be Peyton Milton. And so I'm not done talking yet.
Absolutely.
And so just in looking things here, Peyton Milton has a few issues going on. For one, he's got a warrant, a felony warrant out of Skagit County Superior Court for an animal cruelty charge. He needs to take care of that. He's also got a DUI out of Thurston County District Court. And I'm going to tell you whether or not a court date has been set for that or not. At the moment, no court hearing has been set on that. Peyton Milton on April 11th was in front, which is just a few days ago. Well, I guess maybe a little over a week ago now, about 2 weeks ago now. Was in front of the court. He was released, and Thurston County Public Defense was appointed. That can change if you wish to represent yourself or not. That's fine, one way or the other. And then there's this case, which might actually be the least of your worries. It's a criminal trespass, the least of Peyton Milton's worries. There's a criminal trespass out of the city of Lacey. It was alleged to have occurred on March 31st. Bail's been posted, and this is what's known as a pretrial. Pretrial is the opportunity to resolve the case short of trial. A lot of times someone's represented by an attorney, they'll speak with the prosecuting attorney. Someone's represented by someone represents themselves, they can speak with the prosecuting attorney to resolve the case somehow. If the case doesn't resolve, then the case gets set for trial, and then there'll be a jury trial, and then then a jury will determine whether the person accused, Peyton Milton, they might at a threshold place, they may determine whether whoever, depending on who shows up, whether that person is Peyton Milton or not, and then the jury will decide one way or the other as to whether you found guilty or not guilty of the crime charged. So that's where we're at. And if you're here, again, you said you're representing yourself, and if you want to resolve the case here, I'll give you a chance to speak with the city. If not, we're going to set it on the trial track, and we're going to set it to the last known Peyton Milton's address. And if you show up and represent yourself as Peyton Milton at the trial, which you certainly have a right to do, a jury will determine one way or the other as whether or not you're guilty or not guilty of criminal trespass. I will tell you in a minute where the notice, it's important that you get it, where the notice that the DUI.
What begins as a routine identity question quickly spirals into confusion. The defendant refuses to confirm who he is, insisting he's merely an agent, while the judge tries to establish basic facts. You can feel the tension build as the court realizes this won't follow normal procedure. By the end of this segment, The judge shifts from patient to firm, setting the tone for a much tougher exchange ahead.
Is charged. Make sure you get that. It's going to be important that you get that. So in terms of whether, well, I don't have to answer that question or not. I mean, that's not. I will tell you that's not getting you anywhere, and so it's just not. And so I guess what I want to know from you is where we're going to go for this case today. Is this case going to resolve today, or does it need to be set for trial?
Well, I am looking towards a resolution. Unfortunately, I have not been able to contact Matthew Sharp as of yet, despite reaching out to him. I have some exhibition lists here to put in.
Okay, so just you don't need to raise your voice. You can just
Sure.
so
Just
in terms of they're exhibits, not exhibitions, but exhibits, those are for trial if you want to convince the jury. And so if you're of the position you didn't, I'll give you an opportunity to speak with them now. You can step out, go off the record, and if you can resolve the case here now, that's fine. If not, then we'll tee it up for jury trial and go from there. You can stay seated.
Okay.
You don't need to get up. And so, but I am also going to hear from him. I'm not going to force him into doing anything he doesn't want to.
Absolutely.
So, Mr. Sharp, what's your position on all of this?
Okay, well, a few things. I'd point out at the first hearing, Mr. Miller was held on bail, and he also shared at the time that he wanted access to a computer to work on his defense. And so actually put a lot of time in thinking how to make that happen and put a discovery packet together, and then found out that he was able to post the bail. So I've got the discovery to deliver to Mr. Peyton Milton if that's who this is, and he'll take it. We've printed off everything that can be printed off. There were a few things that are video. You can't print a video, of course, so they're on a USB drive, hopefully in a universal enough of a format. And being out, I trust that Mr. Milton can now access a computer to do what he's got to do with that.
Again, I'm going to stop you there for a second because I didn't realize where we were on discovery. And he can give that to you, but this is where you do got to admit you're Peyton Milton, because he's got a responsibility to give that either to the defendant or the defendant's attorney. And if you want that discovery right now, then you do have to agree that you're Peyton Milton.
I am the agent authorized to represent him.
No, that's not. That's again. You don't. Okay, look. Again.
I have.
Okay, stop.
Sure.
Stop. Okay.
Sure.
So,
Respect to your honor.
Thank you. Being the agent for Peyton Milton isn't good enough. Unless you're an attorney with a bar number, then you can represent Peyton Milton. You're either Peyton Milton representing yourself or a third person representing Peyton Milton, with which you can get the discovery. If you're a third person representing not Peyton Milton, representing Peyton Milton, then you don't, unless you're an attorney, then you don't get discovery. So that's where we're at.
Well, unfortunately, Your Honor, if I am a layman, as I claim to be, and as a layman, I'm not made to understand the law as yourself, Your Honor, and Matthew Sharp over here as an attorney who has passed the bar, then I'm not really certain where to proceed as being in front of your capacity as a neutral arbiter. This is I'm simply here to put in the exhibit list for who is known as Peyton Ansley John Milton in all capital letters on the court docket in front of you, so that my bail would not be revoked, and I would have to be incarcerated and refuse my reasonable accommodations to defend myself pro se as the agent authorized to represent Peyton Ansley John Milton.
Good city auditor, an idea. I'll point out, last time I was at a hearing with Mr. Milton, we were working on just these two cases with Lacey. So there's a second one with Lacey, Your Honor, if you didn't catch that. There's a assault case that's on a stipulated order of continuance from just a month or two ago. But since then...
Did he have an attorney on that?
No.
Okay.
That was... Well, Miss Langley was originally. She's no longer.
Okay, but did she sign off on that agreement? Was she represent him for the resolution?
Yes, Your Honor.
Okay, all right. Was that, and you agree that you entered that resolution?
March 22nd.
Are you speaking with me or Matthew?
Yes.
I have paperwork here that has no signatures from anybody in regards to the simple assault in the SOC. I've just acquired that today, as a matter of fact. So
all that's coming as news to you?
That's a good question. I do know that I have a motion here to suppress an SOC dated on 3/22. signed under duress of life, liberty, and freedom being threatened without just cause.
Here, the judge outlines multiple legal issues, warrants, DUI, and trespass, making it clear the situation is far bigger than the defendant is treating it. Meanwhile, the defendant tries to push paperwork and exhibits without understanding the process. The prosecutor steps in, adding more structure and pressure. This part shows a clear imbalance. The system is organized and experienced, while the defendant is improvising in real time.
So, Your Honor, I'm sorry, I was in the middle of the thought there. Since that all happened, now there are the state charges too, and that's maybe more serious, the DUI and the obstructing charge. And I understand counsel was appointed there. Maybe I'm mistaken, that's what the docket says.
It does say that.
So I was going to suggest the court inquire with Mr. Milton again, because it's more complex now with state cases involved. The stakes are higher for sure. Whether he still wants to proceed pro se, I mean, I'm hearing, the disadvantage of being pro se is real. But if there's counsel on the state case, maybe that's an option here. Also, standby counsel may be a beneficial option. There was some obvious friction with Ms. Langley, but she's not the only attorney available.
Right. So you wish to represent yourself?
As the agent authorized to represent Peyton Ansley John Milton, that is correct, sir.
Okay, I'll take that as a yes. Okay. If you ever, and you're not a lawyer.
Well, obviously.
Did you pass the bar exam in Washington State? Do you understand why I'm asking these questions?
As a layman, I'm not meant to, but as the agent authorized to represent myself, I do. Yes, Your Honor.
Okay. Well, I'm going to explain it to you anyway.
Appreciate that.
You have the right to represent yourself, and so but everybody also has a right to be represented by an attorney. And if you can't afford an attorney, I can appoint an attorney to represent you, either Ms. Langley or, again, if that doesn't work, she's not the only attorney on contract. The concern is when if someone goes to trial without an attorney, then get convicted, then on appeal they can say, oh, I wasn't effectively represented because I chose to represent myself. As a judge, I'm required to ask a few questions just to make sure that you're going into this process with your eyes open and you understand fully what's at risk. That's why I'm asking. I'm just putting on the record to say whether you're a lawyer or not.
I understand that, Your Honor.
And so again, I'll ask it again.
I understand that I'm at a huge deficit here representing myself pro se.
Great. And so, but the answer to the question is you're not a lawyer.
As a layman, I'm not meant to understand the law in the same manner as you, Your Honor.
Okay. So as a layman, when you say as a layman, I'm going to take that to mean that you're not a lawyer and did not pass the bar exam. Is that fair?
That would have to be true.
Okay.
As a neutral arbiter in your position.
Nothing necessarily has to be true. And you had already said you understand that you'll be at a disadvantage, and that Mr. Sharp is an attorney. He knows the rules of procedure, rules of evidence, and whereas you might not be as well acquainted with those as he is. You agree with that?
Yes.
Okay.
I would feel foolish disagreeing with that.
Okay. And then have you ever conducted a trial before?
No. I'm excited for the experience.
Why?
I'm sick with it, Your Honor. To put it in Western Pacific Northwest slang terms.
I don't understand that answer.
I'm I'm a kung fu teacher internationally, and I have an interest in law on the side. I'm a kung fu teacher internationally, and I have an interest in law on the side. My passport that was stolen from me the same night that I was under arrest for the first simple assault that is being brought up today concerned me, because the same day I was neglected having somebody who had broken the law against me searched from the same officer that arrested me for defending a senior citizen, which...
The judge carefully walks through the risks of self-representation, asking direct questions about legal knowledge and experience. The defendant responds with vague and unusual answers, even bringing up unrelated personal details. As an observer, you can see the judge testing whether this is a knowing decision or a risky misunderstanding. By the end, it's clear the defendant is stepping into something he doesn't fully grasp.
I regret to to digress or inform that I'm not a criminal, you know. I'm really just going through this because I have faith in the system that if I'm not doing anything against the community standard that should be being held up by people in the position of level 0 government, sovereign, citizen officials, there should be no reason why I wouldn't be allowed to offer witness and testimony from my exhibit list to clear my name of this criminal trespassing in the first degree, to hopefully clear off this simple assault charge that I went out on a leap of faith that my justice system would take care of me in defending it. Does that answer the question?
It doesn't.
No, I just
because here's my perspective on this, and we'll get through this here pretty quickly because I have an idea of what's going to happen here today. Well, first of all, let me back up a little bit. Are you aware that Peyton Milton had a felony warrant out of Skagit County?
I've never been officially made aware of this by any.
Consider yourself make aware of it now. You have that warrant.
Sure.
You need to take care of that.
Yes.
And here's the thing. So criminal trespass in the grand scheme of things, that's far from the most serious type of offense we see around here. DUI is a little bit more serious. That carries with it some fairly more harsh consequences, I guess is the way it is. And most people, you have said yourself a couple of times, well, as a layman, I'm really not familiar with the court. Most people, pretty much all people in your situation, when they come in a situation where they're not familiar how things work, and lay people who aren't as sophisticated or understanding the rules of evidence and sophisticated in their knowledge, you might be very sophisticated, but sophisticated knowledge or awareness of the rules of evidence, rules of criminal procedure and so forth, when they get the opportunity to get an attorney, they jump at it, because this attorney's been through here on a daily basis. And just let me finish, please. I let you finish, so let me. And so they want to take advantage of the expertise of that attorney. And again, the attorneys who are public defense, they're here every day. They may not seem like it, but they seen just about everything under the sun, including this, the routine about red agents and on their behalf and all that sort of stuff. This isn't news to me, Mr. Sharp, or anyone else who may be appointed to represent you. I've yet to see it be successful, though. Who knows? You might be the first.
I doubt it.
But anyway, most people take advantage of that. But you do have the right to represent yourself if you wish to do that. Based on, comments that you have made, combined with what Mr. Sharp has said, and that you're here, made the comment that you are here to represent yourself, I am going to make a finding that you are Peyton Ansley, have gone by the name Peyton Ansley John Milton. You were the person who was arrested on this and posted bail and are now here. And in that respect, you can provide him the discovery that's available. You can give him right now. I don't see, Mr. Sharp, unless you disagree with me, based on everything I've seen thus far, I tend to doubt any sort of resolution is going to be reached here today. And so I would just be inclined to set this for trial, and then we'll go from there. And if you change your mind about an attorney, you can do that. So the address we have for Peyton Milton, and mail needs to be set on that. Again, that DUI, you shouldn't ignore.
Oh, absolutely.
Good. Don't go to sleep on that DUI. And again, I don't know what happened in Skagit County. I can look here in a minute. But notice on that DUI is going to be sent to that address. Are we pretty sure Peyton's going to get it?
5213.
That's it.
There's no excuses that could be articulated that he would not receive that piece of mail.
Good to hear. Does he have a
report.
cell phone where we can send text reminders to?
Well, I can't say no to that. I do have to express that all my physical possessions, or all of Peyton Ansley John Milton's physical possessions, were stolen from him on 3/16 for the original arrest.
All right. Well, okay, then if you don't have one, you don't have one. Not everyone does.
Well, I do have access to the phone number as it is through an application. But mail would work a whole lot better.
Well, we would do both.
Perfect.
But before you go, last thing I'm going to do, just to let you know,
This segment shifts into a reality check. The judge highlights the seriousness of the charges, especially the DUI and outstanding warrant, and explains how people in similar situations usually rely on legal counsel. There's a noticeable change in tone, less patience, more direct warning. The courtroom dynamic becomes one-sided, with the judge essentially signaling that this approach has failed many before and is unlikely to succeed here. All right, guys, this is the moment where everything comes together, and the final message hits hard.
Looks like charges were filed. Affidavit of probable cause was filed on March 2nd, 2022. There's been no
March 2nd
of 2022, over a year ago.
Oh,
And there was a declaration of mailing on March 27th. There was a motion hearing on March 20. There was a declaration of mailing on March 7th.
now was that mail?
Let me finish, please. I don't know where it was sent. That's
Okay.
Skagit County Superior Court. I can't say.
Gotcha.
But I will say that on March 7th, there was a declaration of mailing. On March 22nd, a motion hearing was held and a warrant was issued. So that warrant's been out for a little over a year. So you need to pay it. That's a felony.
To have a warrant out for a year. Gotcha.
It's a felon. It's a charge out of Superior Court, which
Gotcha.
makes it a felony.
Right.
It's animal cruelty in the first degree. And I don't know anything about it other than that. And with that, Mr. Sharp, unless you have any other comment, that'll conclude today's hearing.
I'd just like to clarify for Mr. Milton's benefit, if he decides that he would like to work with an attorney, I understand that the process would be call the court and ask just for a hearing to be reviewed for appointment at any time. It would need to be scheduled, and it'd probably take a little while to, I think, schedule probably a couple weeks out. But Mr. Milton, if you decide you want to do that, that would be the way. Just call the court and ask for it.
May I please approach and disperse these exhibit lists? From
Well, you can give it to, if Mr. Sharp will accept it, sir, you can give it to him.
May I give you this copy?
I mean, we don't,
Case number
is
is
a
on.
copy, so I'll point out that an attorney would know the proper way to do this and whether to file it concurrently with the court or not.
I
This
was
looks,
on my way to your building.
this looks like an original.
I have 3 originals technically here, but they all have the same.
And I'll give you
Mr.
the-
Sharp, does he have your contact information? Do you want to,
Kind of leave the phone number.
thank you.
Would you like this for your book?
I'll take it. Yeah, we go. So if it's the same thing, is this identical to what you got, Mr. Sharp?
I didn't get it
It
examined
absolutely
for,
ought to be.
I didn't get a look at it for that, Your Honor, but I can check the court file later to verify.
Appreciate that.
I'll receive whatever this is, right?
Give
Are these,
me,
okay,
behind
are these
on my
witnesses you wish to call?
Yes.
Okay.
These are witnesses who have agreed to provide witness or testimony, whether it be written or appearing before the court.
Do you know how to get those witnesses in front of the court?
I have already made contacts and gotten her to agree that she would be willing to testify or
Okay.
provide
And
testimony.
again, that was a yes or no question.
Yes.
Okay.
The answer is yes.
I don't think you do,
On-
because you need to do
on
more
at
than
least
that.
2. I've made contact with 2 out of the 6. One of them is the arresting officer that I want to testify.
I'm
for.
reasonably confident that the city will subpoena him.
Precisely. So
And again, I'm not gonna, I guess, I know I said this was over, but I'm gonna try one more time here. That's not enough to get a witness in front of the court, just to go talk to him and say, hey, would you mind showing up? And if they say, yeah, that doesn't do it.
right. That's why I'm preparing witness and testimony, written, signed statements.
Yeah,
dated.
you're not gonna be able to give written testimony. If
No, I
someone,
won't,
if you
but-
just ask someone and
won't
they
they?
choose not to show up,
right.
you can't give a written statement.
Precisely. So I'll have to get written statement, signed, dated, and then have them show up as a witness. Is
Yeah,
that correct?
But there's a process to get them to show up,
Okay.
and you clearly don't know what that is.
I believe I've begun it effectively and properly.
And I can't. Probably Mr. Sharp's over there thinking there I've gone too far already. I can't be the one to tell you how to do it, because I can't sit there and tell him what to do. You don't want me to do that. I can't sit there and tell you what to do, or the defense attorney, and that wouldn't be fair either. And
I'll
so,
have to get together before the next court date.
he doesn't have to do that.
Oh.
And hang on,
Sure.
you're talking to me.
Sure.
I'm talking right now, right?
Absolutely.
And so when you prepare witnesses and get them into court, there's a way any defense attorney would know how to do, and you clearly don't. And so I'm just telling you this just so you hope you go into this with open eyes. And so I have a feeling I'm picking up that, and I'm sorry for being blunt, is you really don't know, and again, this is criminal trespass, which again, is not the end of the world. You really don't know what you're doing. You really don't. And I think it would be to your great benefit to have someone with you who actually does. And that's as far as I'm going to go with it. And again, the opportunities right now, we could still appoint someone. Mr. Sharp has said, and I agree with him, if you want to contact the court and get an attorney, but one was been appointed in that DUI, and I don't know whether you're going to reject her or not either. But as of right now, you have an attorney in that DUI, and you'd be doing yourself a huge disservice if you approach that case the same way you're approaching this one. Maybe I'm going too far in saying that, but
I appreciate your expertise.
Yeah, I've seen a few. I've been at this for a few years there, Mr. Milton, and I've seen a few people represent themselves, and I don't know that I've ever seen it go well. With that, and that's going to be my last comment on this. If you'll conclude the hearing, you're free to go.
Thank you,
then keep your eye in the mail. We'll see you back here at the next. I don't see any point in a pre-trial. We'll just set it for a trial.
No, but I would like to give you my.
The judge delivers a blunt assessment. The defendant doesn't understand the legal process, especially when it comes to witnesses and trial preparation. Despite multiple warnings, the defendant continues forward, and the court decides to move the case toward trial. It ends with a strong sense of inevitability. The system moves on, and the risks are now fully on the defendant. Make sure to like the video, subscribe to the channel, and we'll see you in the next video.